A Supreme Court ruling recognizing former President Donald Trump's immunity claim for official acts as president, though rejected it for unofficial acts. The majority opinion delivered by Chief Justice John Roberts, while the president is not above the law, that he may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive prosecution for his official acts. Still, it states that Trump is asserting a far broader.
Okay, folks, sit down for this one, because what I'm about to walk you through is one of the most documented and closely watched civil litigation situations involving any American president in modern history. A saga that has unfolded over years with jury verdicts, appeals, bonds, and now a petition sitting before the United States Supreme Court that could have ripple effects far beyond the parties involved. The Jean Carroll cases have produced combined jury verdicts totaling around $88.3 million against Donald Trump, consisting of two separate trials and outcomes that together paint a picture of sustained legal accountability through civil mechanisms in a way that stands out for its scale and persistence. The first verdict came in May of 2023, approximately $5 million on claims of sexual abuse and defamation, while the second in January of 2024 delivered about $83.3 million focused on additional defamation claims stemming from Trump's continued public statements after the initial allegations. Trump appealed these rulings to the United States Court of Appeals for the Second Circuit, which affirmed the decisions, leading him to petition the Supreme Court for a writ of certiorari. That petition argues, among other things, that the trial court's handling of evidence violated certain federal rules of evidence, specifically Rules 413, 400, and 404B, while also framing the entire proceedings with language about the mistreatment of a president, suggesting that his unique position as a political figure and later as president again should weigh heavily in how the courts evaluate the case. America First Legal, an organization founded by and closely connected to Stephen Miller, who serves in a senior policy role in Trump's second term, filed an amicus brief on December 11, 2025, supporting Trump's petition and echoing that framing of presidential mistreatment. On the other side, Roberta Kaplan, representing Jean Carroll, submitted an opposition brief on January 14, 2026, pushing back firmly and arguing that the petition does not present any compelling federal question that the Supreme Court needs to take up, that the lower courts applied the rules properly within their discretion, and that the case does not warrant the extraordinary intervention of the highest court in the land. A bond of $9.63 million. Wait, no, more precisely, the larger $91.63 million bond tied to the bigger verdict sits in escrow right now, pending whatever the Supreme Court decides on whether to grant review or let the lower court outcome stand. The case has been distributed and redistributed for conference at the Supreme Court since around February 20, 2026, a pattern that often signals the justices are giving it serious consideration, even if they ultimately deny certiorari, as multiple rounds of review can indicate deeper interest in the legal questions or the broader implications. This entire cumulative pattern represents one of the most significant pending civil litigation matters affecting any sitting or former American president in recent memory, carrying substantial financial stakes, legal precedents, and political undertones that make it impossible to ignore if you're trying to understand the full landscape of accountability in high-profile cases. But before we dive deeper into every layer of this, let's be honest for a moment. You can't always trust the mainstream media to give you the unfiltered context without their own spin, which is exactly why platforms like Pump Politics exist, to cut through the noise, deliver real stories backed by court documents and verifiable records, and provide the kind of detailed analysis that helps people form their own views without corporate filters or partisan talking points dominating every angle. If you want to stay ahead of these kinds of developing headlines with daily insights dropped straight to your inbox, no fluff, just substance, go ahead and join our free newsletter. The link is right there in the description, and it costs nothing to sign up and get that edge. And if what we're building here resonates with you, if you value truth-seeking over echo chambers, consider joining the community that supports independent work like this, because every bit helps keep stories like this one fully explored without outside influence. All right, with that said, let's get right back into the heart of the matter and walk through the Jean Carroll case background in thorough detail so you can see how this all connects. Jean Carroll, a longtime journalist, advice columnist, and writer with a career spanning decades in media, first came forward publicly with her allegations against Donald Trump in 2019 as part of a larger project examining patterns of behavior among powerful men. She detailed an encounter she said occurred in the mid-1990s inside a dressing room at Bergdorf Goodman, a luxury department store in Manhattan, where she alleged Trump sexually assaulted her. Trump has consistently and vehemently denied the allegations, calling them fabricated and politically motivated, and he made a series of public statements denying her claims and questioning her credibility, motives, and even her appearance, Statements that Carol's legal team argued crossed into defamation by harming her reputation and causing emotional and professional damage. Those statements led to civil litigation that combined sexual abuse claims under New York's Adult Survivors Act, which opened a window for older cases, with defamation claims, and the cases wound their way through the federal courts in New York over several years, involving extensive discovery, depositions, motions, and ultimately 2 separate trials before different juries. The May 2023 trial resulted in a verdict finding Trump liable for sexual abuse, not the full rape as sometimes mischaracterized, but the legal finding of forcible sexual contact, along with defamation for certain statements. The jury, after hearing testimony from Carol, her friends she confided in shortly after the alleged incident, experts on trauma, and other evidence, including the infamous Access Hollywood tape where Trump discussed grabbing women without consent, awarded roughly $5 million in damages, a mix of compensatory and punitive amounts meant to address the harm and deter similar conduct. That verdict was significant not just for the dollar figure, but for the jury's acceptance of the court allegations after weighing the evidence presented in open court under standard rules of procedure. The January 2024 trial zeroed in on additional defamation claims tied to Trump's ongoing public denials and attacks even after the first verdict. Statements made on his social media platform, in interviews and elsewhere that Carol's side said further damaged her and compounded the original harm. That jury deliberated relatively quickly and came back with an $83.3 million award, including substantial punitive damages, bringing the total across both verdicts to $88.3 million, one of the largest civil judgments against a major political figure in contemporary American history. These outcomes didn't happen in a vacuum. They stemmed from months of pretrial proceedings where evidence was vetted, witnesses deposed, and legal arguments tested. Consider the deposition Trump gave in 2019 or around that period for the case, moments from which became pivotal at trial. In one notable exchange, when shown a photograph of Carol from years earlier, Trump appeared to confuse her with his second wife, Marla Maples, a mix-up that stood out because he had publicly declared that Carol was not my type, implying the encounter couldn't have happened for that reason alone. That confusion, captured on video and played for the jury, undermined parts of his defense in the eyes of those deciding the facts, as it suggested possible misremembering or inconsistency in how he viewed the plaintiff. Beyond that, Trump's history of sworn testimony in other contexts, such as the 1990s deposition where he admitted using the pseudonym John Miller to call reporters and praise his own business dealings and personal life, added layers to the broader evidentiary picture that juries could consider when assessing overall credibility on disputed factual questions. The discovery process unearthed documents, messages, and patterns that the plaintiffs argued showed a consistent approach rather than isolated incidents, all of which fed into the cumulative case the juries heard. These elements weren't just background, they formed the foundation for arguments about liability and damages, with the juries ultimately siding with Carol after hearing everything presented under oath and subject to cross-examination. Now, turning to the bond context that keeps this financially real even during appeals, after the larger January 2024 verdict, Trump posted a $91.63 million bond, which covers the judgment plus interest and costs as required under standard New York civil procedure to stay enforcement while appeals move forward. That bond, underwritten by a Chubb subsidiary, sits in escrow today, meaning the money is secured and can't be touched for other purposes until the courts resolve the matter. If the Supreme Court denies certiorari, that bond amount would ultimately transfer to Carol, providing her with the awarded compensation after years of litigation. If review is granted, it stays put while further proceedings play out, potentially extending the timeline but keeping the financial pressure in place. This bond requirement is not unusual. It's designed to protect prevailing plaintiffs from defendants delaying payment indefinitely through appeals, while ensuring defendants aren't forced to pay prematurely if they have strong grounds to overturn the verdict. In Trump's case, it represents a massive encumbrance on liquidity, limiting what capital is freely available for business, political, or personal needs at a time when other financial obligations from separate cases also loom large. The scale of it, nearly $100 million tied up, underscores how civil litigation can impose tangible restraints even on the wealthiest individuals when juries find liability. Let's spend some time on the amicus brief from America First Legal, filed on December 11, 2025. This organization, led in significant ways by Stephen Miller, who holds a high-level White House position in the current administration, submitted arguments urging the Supreme Court to take the case, emphasizing what they describe as mistreatment of a president through biased evidentiary rulings and an overall unfair process that they say deviated from standard legal norms. The brief positions the litigation as part of broader lawfare against Trump, arguing that allowing the verdicts to stand would set dangerous precedents for how political figures are treated in civil courts. It highlights concerns over the admission of testimony from other accusers and materials like the Access Hollywood tape, claiming these improperly prejudiced the juries beyond the specific facts of Carol's claims. This kind of external support from aligned groups is common in high-stakes Supreme Court petitions, providing additional perspectives and sometimes political framing that can influence whether justices see broader constitutional or systemic issues worth reviewing. Miller's dual role creates an interesting structural dynamic, blending outside advocacy with inside administration influence, which adds another layer to how these legal efforts are coordinated and perceived. In direct response, Roberta Kaplan's opposition brief from mid-January 2026 dismantles those arguments point by point, asserting that the trial court's decisions on evidence fell well within established discretion under the federal rules, that no novel or compelling federal question exists to justify Supreme Court intervention, and that the mistreatment of a president rhetoric doesn't override the substantive merits or the jury's factual findings after full trials. Kaplan, a seasoned litigator, has handled the case meticulously from the start, building a robust record that withstood Second Circuit scrutiny, and her filing emphasizes that civil cases should turn on evidence and law, not the defendant's political status or current office. This back and forth in the briefing process is standard but illuminating here because it lays bare the core tension, whether ordinary civil rules apply uniformly or if prominence demands special accommodations. The Supreme Court's conference distribution since February 20th, with redistributions, suggests the petition isn't being dismissed out of hand. Justices often use multiple conferences to dig into complex evidentiary or immunity-adjacent questions, even if the ultimate decision is to deny review and let the lower court's work stand. The Trump v. United States immunity decision from July 1, 2024, which focused on federal criminal prosecutions and official acts, doesn't directly shield against this civil matter, which arose from private conduct predating his presidencies and was litigated in state/federal civil courts under different doctrines. Civil accountability mechanisms like these cases continue to function independently, providing avenues for redress where criminal immunity might limit other paths. Justice Sotomayor's dissent in the immunity case warned about creating a king-above-the-law scenario, and cases like Carroll illustrate how civil and state-level processes can fill potential gaps, ensuring that powerful figures remain answerable through juries and standard procedures. The $91.63 million exposure here operates purely through civil channels distinct from any criminal context, highlighting the multifaceted nature of legal pressure. Expanding on this, the evidentiary arguments in Trump's petition center on Federal Rule of Evidence 413, which allows similar acts evidence in sexual assault cases under certain conditions, Rule 415 for civil context, and 404b regarding other crimes or wrongs to show motive, intent, or pattern rather than propensity alone. Trump's team contends the trial judge let in too much testimony from other women who accused Trump of similar behavior, plus the Access Hollywood recording, arguing it unfairly swayed the juries toward viewing Carroll's claims as part of a larger pattern instead of evaluating them in isolation. The lower courts disagreed, finding the evidence probative and properly limited with instructions to the jury, and the Second Circuit upheld that. If the Supreme Court grants review, it could clarify the boundaries of these rules in high-profile political cases, potentially affecting future litigation involving public figures where credibility battles often involve collateral acts. But critics of the petition say this is routine application, not an emergency warranting certiorari, especially since the rules have been applied similarly in countless other cases without issue. The combined $88.3 million verdict reflects not just the initial harm, but the jury's view that Trump's post-allegation statements escalated the damage, with punitive elements designed to send a message about repeating defamatory attacks. Juries in defamation cases weigh factors like the defendant's wealth, the malice involved, and the need for deterrence, and here the figures, while eye-popping, emerged from evidence of widespread dissemination via Trump's large platforms. This ties into broader patterns observed in Trump's approach to litigation, where public counterattacks often accompany legal defenses, as seen in statements from aides or his own rhetoric framing cases as politically driven retribution. Connections to other matters, like the Engoron civil fraud judgment in New York for hundreds of millions, with its own reduced bond of $175 million, or the criminal conviction on 34 felony counts still under appeal, create a web of overlapping financial and temporal demands. Add the reported decline in Trump media stock value, wiping out significant portions of perceived net worth and banking pullbacks due to heightened risk assessments, and you see structural pressure on the business empire that once thrived on leverage and brand power. Banks tightening credit, insurers raising terms, investors wary, all compound because legal findings carry reputational weight that markets and institutions can't ignore. This isn't isolated, it's a cumulative effect across multiple fronts. Time spent on depositions, strategy sessions, and court appearances diverts from governance or campaigning. Resources tied up in bonds limit flexibility. Public narratives shift as verdicts accumulate, challenging claims of total exoneration or witch hunts when independent juries, after hearing evidence, reach consistent conclusions. Defenders rightly point out that damages can seem disproportionate to some, that political context might subtly influence jurors in polarized times, that evidentiary calls are debatable, and that prominent defendants often face heightened scrutiny. Those points deserve consideration because proportionality in awards, consistency in rules, and fairness in process matter to the integrity of the system. Yet the counter remains rooted in the record: multiple trials, appellate affirmations, depositions with inconsistencies, and standard procedures followed. The defense ultimately hinges on the idea that political status should alter the application of civil norms, a proposition American legal tradition has historically resisted in favor of equal application of law. Juries decide facts, judges apply rules, appeals test for error, and the Supreme Court steps in only for significant federal questions, not routine error correction. Breaking it down further for clarity, the first key takeaway is the sheer scale of the verdicts and bond. $5 million from the sexual abuse and initial defamation trial, $83.3 from the follow-on defamation focused on persistence, totaling $88.3 with the $91.63 million bond safeguarding it. Denial of certiorari would likely release those funds to Carroll after all appeals exhaust. Second, the specific evidentiary fights under those federal rules, the presidential mistreatment framing in the petition, the America First legal brief adding organizational weight, Kaplan's detailed opposition rejecting any special standard, and the ongoing conference activity since February all converge on whether this case merits extraordinary review. Third, it doesn't exist alone, but alongside the Engeron fraud matter nearing $700 million with interest at one point, the criminal case media valuation drops exceeding $1 billion and more, creating unprecedented simultaneous exposure for any modern president. Fourth, it underscores civil litigation's ongoing role in accountability, unaffected directly by criminal immunity rulings, with mechanisms like bonds, juries, and appeals providing checks that persist. So to Mayer's warnings about unchecked power find illustration in how these avenues keep functioning. Who benefits from how this is played out? Carroll gains potential financial remedy and public validation if the bond pays out. The legal system demonstrates resilience when high-stakes cases proceed on merits. Accountability advocates see proof that no one is fully above civil consequences. Media and analysts get rich material from public records. Future plaintiffs might feel empowered to pursue similar claims against the powerful. On the loss side, Trump bears the direct financial hit, potential precedent effects, distraction from priorities, and narrative challenges for supporters who view it as selective targeting. His coalition contends with explaining substantial jury findings despite denials. The broader empire absorbs more strain amid contracting support from traditional financial partners. Looking ahead, scenarios range from outright denial leading to payment, grant of certiorari, prolonging uncertainty with the bond held, procedural tweaks, precedent-setting opinions influencing political civil suits, or ripple effects on parallel cases. Additional litigation could draw on outcomes here for strategy on both sides.